అది
హలో
కనెక్ట్ కావాలి మైక్ తెచ్చి కనెక్ట్ అవుతుంది కదా.
హలో కనిపిస్తుంది. ఎందుకు రిసీవ్ చేసుకోలేదు తీసుకుని రాయాలి కదా.
Good morning, Gomati ma'am. Are you available? Hello. Good morning, Gomati ma'am. Hello. Good morning, ma'am. Hello. Good morning, Gomati, ma'am. Shall we start the session? Hello.
Sir, I think she is speaking but not audible.
Yes, ma'am. Excellent. Ma'am, your voice is not audible, ma'am.
Hello.
Good morning, ma'am. Shall we start the session, ma'am? Hello. Good morning, ma'am.
Hello.
Yes, ma'am. We are able to hear your voice.
Okay. Now I can.
Okay. Thank you, ma'am.
Sorry for the delay.
No problem. No problem, ma'am. We'll start the session. Okay.
Okay.
Yeah.
A very good morning to everyone. Respected dignitaries, faculty members, research scholars, and the students participants from the various reputed institutions across the country. We will start the program with the blessing of Almighty. Now our girls sing the song.
गजेशानाय बालचन्द्राय श्रीगणेशाय धीमहि एकदन्ताय वक्रतुण्डाय गौरीतनयाय धीमहि गजेशानाय बालचन्द्राय श्रीगणेशाय धीमहि.
Thank you, girls, for the great start. On this beautiful morning, on the behalf of Siddharth Groups of Institution, Puttur, is a privilege to welcome each and every one of you to the brainstorming session 2 on the Impact Lecture session sponsored by MHRDS Innovation Cell, AICTE, New Delhi, organized by Department of ECE, Siddharth Institute of Engineering Technology, Puttur, Andhra Pradesh. We extend our heartfelt gratitude to the MHRDS Innovation Cell, AICT New Delhi, who sponsored this online seminar. Also, we thankful to the eminent speaker, too, who is our resource person, our college management, and all the participants showing the incredible interest. Now I request Dr. R. Prem Kumar Sir, Professor of ECE Department, SciTech, the coordinator of this event, to give the welcome address. Welcome, sir.
Yeah, thank you, Nisha, ma'am. Respected chairman, respected chief guest, our beloved principal, cherished faculty members, and dear participants, good morning to all of you. With the blessings of Almighty, I feel happy and proud to welcome you all for this Impact Lecture sessions on 5th July 2022. I am privileged to welcome our beloved today's program speaker, Srimati S. Gomati Batmatilaga, Scientist B, Pattern Information Center, Tamil Nadu State Council for Science and Technology, Chennai. And she is living in Italy right now. On behalf, even though she is very tight schedule and she is accepting our request in the today morning and as she planned to present. On behalf of our Siddharth Institution of Management and faculty members as well as the students, I heartily welcome you, ma'am. Your presence is making us to feel very proud. With due respects, I extend my warm welcome to our respected principal, Dr. K. Chandrasekhar Reddy, who has been role model to all of us to his hard work and dedication. Welcome you, sir. Next, I would like to welcome to our assistant principal, Dr. Jonathan Raju. Sir, welcome you. Next, I'm happy to welcome our respected president of IIC, Dr. P. Ratnakamala, ma'am. You have been a great opportunity and support and proper guidance to organize this fruitful program. Welcome you, ma'am. Next, I would like to heartily welcome all other heads of the departments for their valuable presence at this greatest moment. I also would like to welcome all the faculty members from various departments of our college to this wonderful program. I express my best wishes to all the participants who are going to acquire more knowledge and be tuned well towards to their goal by attending this program. I ensure you all that this program will profitable for all in every aspects. With due affections, I would like to welcome my dear faculty members who have been working together as a team spirit, involvement and enthusiasm to organize this program in efficient manner. Once again, I welcome you all connected here. Have a pleasant day. Thank you.
Thank you, sir, for the great start. Now I request our beloved HOD ma'am, convener of the event, Dr. P. Ratnakamala madam, HOD of the EC department, SciTech, president of IIC, please give the inaugural address. Welcome, ma'am.
Thank you, Nisha. Respected Chairman, sir, Honorable Chief Guest, Ms. S. Komati Padmatilaka garu, and beloved principals, dear participants, all of our faculty members, a very good morning to one and all. At the outset, I would like to congratulate Dr. Prem Kumar for arranging this impact lecture sessions sponsored by MHRD Innovation Cell, AICT in New Delhi. And I would like to extend my heartfelt thanks to the speakers of today's sessions, Mrs. Komati Padmatilaka and P. Ashwini Pai, for readily accepting our invitation out of their hectic schedule. Thank you so much, ma'am. And this lecture sessions is a sequel of what we have conducted 1 week back. And this time we are grateful to listen from you both the role of IPR in entrepreneurship and also about the patent law. I hope these 2 sessions will really be very useful for all the participants over here. And I thank you once again, ma'am, and I thank you, the coordinator, for giving me this opportunity. Thank you.
Thank you, ma'am. Your words is always encourage us. Now, I call upon Dr. I. Sheikh Arafat, sir, Professor of ECE Department, SciTech, to introduce our chief guest. Welcome, sir.
Thank you, ma'am. Good morning, everyone. It's my pleasure to introduce Mrs. Gomati Padmatilaka, Scientist B, Patent Information Center, Tamil Nadu State Council for Science and Technology, Chennai. She did her bachelor in biotechnology at Kalasalingam University in 2011 and completed her master degree in food technology at Anna University in 2013. And also she did Master of Laws, World Intellectual Property Organization and University of Twin in Intellectual Property. She had more than 8 years of experience in this field. She is IP professional having extensive teaching and research experience, and also registered patent agent under Government of India, serving as a patent consultant and IPR cell expert, skilled in patent drafting, patent search, technology. She is an authorized facilitator for startups in patents and designs under the scheme for facilitating startups intellectual property rights of Government of India. She had awarded with Women Scientist C. Kiran IPR for Fellowship of DST and Inspirational Women Award in 2021. She is qualified in various courses of patent drafting, IP management, and related aspects. She gave 16 guest lectures and 20 above technical workshops organized by TNSCST for the awareness program on IPR. Once again, I welcome you, ma'am, for this today's session. Thank you, ma'am.
Thank you, sir, for your kind introduction. Can I start right away because we are already lagging behind the time? I think I apologize.
Yes, please go ahead, ma'am.
Yeah. And respected principal, sir, HOD madam, and Dr. Prem Kumar, sir, and all the faculties and students, research scholars, a very good morning to you. And so today, I would like to extend my discussion on IPR in entrepreneurship. So this is the right time for India to get into entrepreneurship, and especially in the awareness should be created in the academic sector. So a government is focusing more on this. So let me start my screen, share my screen with you first. I hope my screen is visible now.
Yes, ma'am.
Yes,
Please
ma'am.
proceed, ma'am.
Okay, thank you. So let me first start by the definition of IPR. So intellectual property rights, what do we mean by that actually? Rights, rights are any legal entitlement given by the government to the citizen or the people of the country for a particular, for owning or for performing something. So, these are the rights which can be either general or exclusive in nature. Okay, general rights means these are fundamental rights: right to speech, right to right to freedom of speech, right to vote. All those kinds of fundamental rights are general in nature. That means just because one person is having that right, it doesn't stop other person to have the same rights. But in case of intellectual property rights, these are exclusive in nature. Exclusive means the particular set of rights are provided to one particular entity or a person or a group of people. Others are excluded from using that. This is a kind of negative right. Okay, it's not like right to do something. It's like right to stop others from doing something. Okay, so you are privileged to perform or own certain property, but not others. You can stop, you can enforce your rights, and you can stop others from using that, enjoying those rights. Okay, so property is anything that is owned by a person. This can be either physical assets like this chair, table, laptop, even land, all kinds of tangible properties. But intellectual property is intangible in nature. Intangible, what do you mean by that? Like it cannot be felt by our senses. For example, this collar mic, this is a property of me. Physically it's with me. I have bought it legally, so this is my property. But this is tangible. But the technology behind it, how it actually takes my voice, whether it transmits to the speaker, or how it is integrated to the software in the laptop. So all these technologies behind, someone is owning that property. Okay, someone has the rights over that property. So this is the important basic aspect that you should understand based on for understanding the intellectual property. So intellectual properties are intangible in nature. They cannot be felt by our senses. So the technology, it cannot be seen. We are just seeing the external manifestation of it. That is, its a physical nature is visible, but not that intangibility, like the technology behind it. Okay, not only technology, it can be of a creative aspect, like a picture and a photograph, an artistic work. So So all these creative works are also covered under intellectual property. Okay. And intellectual, obviously, then from the word, it can be seen like it's a creation of mind. Anything that is created under intellectual capability of a human, then it is considered as intellectual in nature. So as a whole, these are the definitions for the intellectual property rights. Okay. So why do we need this IPR protection? India has a long tradition of acquiring and sharing knowledge. We are very happy to share our knowledge, right? So why do we need this protection? Why do someone needs a monopoly over the particular technology or their creative work? Why does it need? Why the system is needed, and how does it work? See, it has 3 levels of benefits. At the personal level, if I am an inventor or a creator, I would expect some recognition. I would expect that I have some connectivity with my work, that I am the author, I am the inventor. That recognition, as well as some monetary benefit from that, some revenue out of it. So from these two, these are the expectations at the personal level when we create or invent something with our intellectual capability. Okay, so at the personal level, with the recognition and revenue, it gives the motivation for further innovation. Okay, so when the personal level benefit is satisfied, it obviously triggers the national growth in terms of economy, in terms of overall development. So it improves the national intellectual capabilities. So with the personal and national benefit, obviously, society is going to be benefited at the end. That means these property rights are given only for particular period of time. Okay, so it's not given for the lifetime. Maybe some trademarks and GI, these are working for lifetime, but it also has to be renewed by the interest of the owner. Okay, so why the government has to give it for a particular period of time? Because after that, say for example, patents, it's like an agreement between the inventor or the right holder with the government. You disclose your invention to the public, and then the government is giving some monopoly over that. Monopoly in the sense, right to exploit, commercially exploit this new technology for a particular period of time. Example, 20 years all over in India. Okay, so after that, what happens after that? After 20 years, the invention goes to the public domain. Public domain means it's given for charity. Anyone can exploit the technology. So that is the ultimate goal. Even personal benefit should be there, but ultimately it should benefit the society. Okay. And during the course of the presentation, if anyone has any questions, you can drop in the chat box. So I forgot to mention that. So who is an entrepreneur? So my presentation is based on startups. Like this, that there is no much difference now as of now at the student level or at the researcher level. It's easy to be a startup. It's easy to be an entrepreneur by establishing a startup. So most of my presentations are giving some views towards establishing the startups using IP. Okay, so entrepreneurs are like nowadays very much encouraged in India, as we have this Make in India campaign, and instead of seeking jobs, it's like the students and especially student community is encouraged towards making jobs. Now the trend is changing ultimately, like you don't have to go for seeking at the end of your course. You can actually give jobs to people. So that attitude has to be encouraged in the student community. So when you do thesis work, for your post-graduation or doctorate, or even graduation. So all those research works are very much important. So it's not like simply do some project, some copy paste, and then you make a thesis out of it and then just finish the course. So you think that is the only requirement for the course, for the degree, right? So that is not the case actually. So when the students are very encouraged to do a disruptive work in their research, in their project, maybe it's a small project, mini project or something like that, but it has to be encouraged towards a patentable subject matter. Okay, all inventions are not patented, cannot be patented. So there are some restrictions that we will, I think in the afternoon, Ms. Ashwini will be discussing about all those aspects. I will also cover in a little bit in this presentation. So IPR plays a very key role when you think of starting your own business. Okay, IPR can be just when we hear the word IPR, we think mostly about only patents. Okay, but it's not the case. Patent is a part of it. Maybe technology-based startups are also there. As technology-based startups are mostly dependent on patents, but there are other forms of IP which are very, very important for business. Okay, so this is the requirement for starting a startup, like in this to register yourself as a startup in a government DPIIT. These are the requirements for a startup, so that you can just go. It's in their website. It's not a big deal, and you can simply give a presentation over that, and they will register you. So it's a simple process that can be done online also. And what are the benefits a startup is getting? Like fast tracking of startup patent applications. There is a procedure that helps the startups to expedite their examination. So the process of patent filing, that this patent application process is a very long one, and it's not definitive. So it can take years. So there is a provision in the patent law, like startups are given some privilege for expediting their examination process. So it speeds up the process. And there is a panel of facilitators that are registered under the government to facilitate IP filings, especially for startups. And other provision is like government can bear the facilitation cost. If you are registering your IP through a startup facilitator, then the attorney fees or the agent fees is borne by the government. Okay, so basically patent office. And there is a rebate on filing of application. That concession is there now in India. Now even concession is for educational institutions registered under government acts. So these are the privileges for startups in related to IP. There are other benefits as well, but these are related to IP. So what are the benefits? What are the advantages of IP protection? So see, IP is like any other property. Like if you have a piece of land, what we'll do, we can either use it for our own purpose, we can rent it, or we can sell it. We can even gift it without any consideration. Consideration means without any payment back. So IP works the same way. It can be transferred. Transferring is nothing but selling it, transferring or assigning. These are the terms that we use, is basically the same. Or it can be either renting is nothing but licensing it. It can be licensed, and so royalties will be earned for every piece of the product with your technology is going to pay you back. Okay, so these are the competitive advantage. Like if you have the strong IP protection for your products and services, and it will actually stop the competitors from using your technology, and it's an advantage. It can become an essential part of the marketing and branding. Obviously, like if you register a trademark and if your technology is patented, so this will be an extra leverage for you to advertise, and it will be extra leverage if you want to find investors. Okay, so all those advantages are there. Intellectual properties are assets that you can use as security against on. This thing that we are not basically aware of these, like intellectual properties, even trademarks and patents, that they are considered as assets, so they can be used for securities as against loans. Okay, so basically when startups are going into IP protection, they do some mistakes. So like do it yourself approach to IP. Like now in India, IP awareness is very less, and we are progressing, of course. After this 2016 national IPR policy, we are more focused on awareness creation. And so it's like some startups do the mistake of not relying on any other IP council legal experts. So they think that they can do it on their own, and it's about investment of money, right? You cannot make any mistake over that. And for example, if you want to register a trademark, so you instead of directly going for filing it, I mean, you have a logo, you have a brand name, but before that you have to do a search in trademark database. So it will show that whether it will be your mark is as strong as it can be registered, whether or whether it relates with any other any other's application, or whether it relates with the it really infringes. Infringement is nothing but a violation of others' right. Okay, whether it infringes others' rights. So all those things can be seen beforehand, before filing for application. So this is one example. So it's better to have a consultation from an IP council before going for that, before investing money over that, money and energy over that, and money, energy, time, obviously. And improper document foundation. The same goes with patenting. Like patent drafting is very, very important, so that whatever you have covered in the patent document, that will be only the things that you are protecting for the lifetime. So it has to be a proper, the claims part has to be proper, the language of the claims and what you're covering in that, all those are very important. So it is advisable to a patent counsel to have you advice with you, instead of straight away thinking you can do it. Obviously you are researchers and you know your technology very well, but these are legal documents. These are techno-legal documents. So you need some legal help, of course. Okay. So, and ignoring standard IP policies in the race to market. So straight away going to market without IP protection. That's a very, very bad mistake that any startup can do. Not only technology protection, it goes with the copyrights and other IPs also. Okay, failing to, because once you publish, once you use your technology, it lacks lacks novelty. Okay, even if you are the one publishing your work, it will lack novelty and it will affect patenting of your technology. Okay, so it's like you are giving it to charity, and the competitors will be aware of it, and all those things are complicated. Failing to implement appropriate confidentiality control and controlling your employees and whoever you are communicating with. If you are finding investors, you will disclose certain things to them. So for that, you need to have a non-disclosure agreement prior, so that it will be they will be stopped. They will be restricted to disclose the information to further other third party are using or exploiting the technology themselves. Okay, so these are the confidential controls that you need to maintain even with your own employees. So in the employment deed, you have to mention that what are the confidential informations which should not be disclosed, also which should not be disclosed even the employee is leaving the company. So all those things have to be thought very early, at the very early stage, and there should be a clear IP strategy. Okay, in big multinational companies, they have a big IP portfolio with thousands of patents. Some are expired, some are still valid, and they properly manage it. They choose which IP has to be survived or which has to be let go. All those things are happening in a higher level. But in case of small entrepreneurs, at the starting level, it's better to have a clear IP strategy. What are our IPs and how do we protect it? How do we maintain it? It's not just filing a patent, filing and granting. It's not enough. You have to maintain the patent for its lifetime. So the renewal fees and all those things have to be considered. So these are already almost discussed here, like first create the IP and make the protection of it as a very top priority, register it, and then you can sell it. Even if you don't want to commercialize it on your own, you can sell it for a particular amount of consideration. Use your IP for collaboration, cross-licensing. You give one technology, take another technology from others. So your IP can be a very great leverage for the negotiation process. And donate, you can also donate IP. See, sometimes patent system works like that. If the inventor, as a researcher, if it is a very important invention, like a drug for the pandemic, something very important, so you don't want to have monopoly over that. You don't want to raise the revenue out of it. You want to give it to charity. But even then, it's advisable to protect it and give it, because if you just leave it, if you just publish it, and if anyone can make use of it, it can be misused by the others. So it's better you protect your IP, and you can choose who are the people who are going to exploit, who are going to use, commercialize it. Getting money or not, it's your choice. Okay, so even then, it's donating your IP also, it's better to protect it first. Okay, so due diligence of IP rights and implementing clear policies, agreements, all those things. And talking about IPR, there are many forms of IPR. Not only patents, we have trademarks, copyrights, trade secrets, plant variety protection, industrial design, geographical indication, traits, and semiconductor layout. So see, all these forms of IPR, they protect, each and every form of IPR protect a particular aspect of the product or service. Okay, so we will discuss what is covered by what. Okay, so all these IPRs are very important in terms of business. So patenting is not the only goal. So let me go through each form of IP in brief. Patents are given for only technical solution for a problem. Okay, so it has to be, like I said, the technology behind the mic. So for that only patents are given, but there are some criteria for patentability. All inventions are not patentable. It should cross, other things are already mentioned. Territoriality. Territoriality is very important for all the IPR. Like if you want to register, if you want to apply for patent in India, if you want to commercialize your product in India, you apply and get the grant in India, and you have right only in India. If you want to commercialize the same product in other countries, you have to apply separately, There are other procedures that you can commonly apply, and still the decision will be taken by individual IP officers in every country based on their own regional law. Okay, so there is nothing called international patent, universal patent. There is nothing like that. Every country has their own jurisdiction there, and they are the decision makers. Some common grounds are there. Some international treaties like TRIPS agreement, all those common agreements give some standards, but ultimately every country has their own legislation based on their cultural needs and other aspects of their country. Okay, so this territoriality is an important aspect of IP. And for example, if you have a patent in your India for particular technologies and not in US, some other person can exploit your technology in US, but not in India. And they cannot import to India as well, import or export to India. But the thing is, they cannot file for patent in another country because that will affect the novelty. Because you have already filed, that's your technology, your application will be the prior art for their application. So they cannot claim for patent, but they can exploit it as you don't have patent in US, in the particular country. Okay, so term of patent is 20 years. See, these are very, very simple things, you know, like paper clips. You would never imagine this paper clip has a patent. So this, I wanted to insist that patent is not only for high-end technologies, big research labs, and scientists, all those people. Patent is for every person who has an intellectual capability, starting from 4-year-old kids. They even have patents. Okay, so that's a myth that patents are like alien high-end aspects. So these paper clips, now the patent is not valid, obviously, because this is very commonly used now. Okay, imagine if the patent is valid, about how much he would be earning for each piece of paper clip. We are paying indirectly, we will be paying indirectly royalty to that patent holder. See, this is the first version of paperclip which was filed. This was patented. Maybe the criteria has evolved over time. Criteria for patentability is differing, but I just want to insist that even simple things can be patented. See, 400 paperclip variations are there. By seeing this, first, when we see this thing, we would never think there is any modification of it, where there is any variation of it, but it is possible. Okay, so patent technology is not going to come down from the other world. It's like we are just improvising over the existing technology, existing prior art. But there should be some criteria for patentability. So these are some of the variations. And like I said, there are certain criteria with any invention to be considered as an invention has to pass through these 3 doors. Invention can be a product or a process. Okay, so novel, it should be novel. So anything in public domain, anything already in the prior art, which is published or which is used in the public, all those things, they are not novel in nature. So any simple modification of it will clear the novelty. And the critical aspect is non-obviousness, the inventive step of it. Inventive step means like it should not be obvious to the person skilled in art. Person skilled in art is a person who is a hypothetical person who has average experience, average skills in the particular domain. Okay, so it should not be obvious to that person, and it should have some industrial application. Without usefulness, because all these IPR are for commercial exploitation, business purpose. So there should be an industrial application. Industrial application is nothing but whether it can be used in an industry or made in an industry. Industry covers everything. Even agriculture is an industry. Okay. So there are certain things which cannot be patented. Apart from these three criteria, there is a provision, section 3, which clearly describes all the non-patentable inventions. This covers invention which are against public order, morality, and simple discovery cannot be patented in India. Discovery of living or non-living substance. So this covers isolation of microbes, isolation of compounds from nature. So simple isolated compound cannot be patented, but the process of isolation can be patented, provided that it satisfies the other three criteria. And new form of a known substance. This is very important in terms of pharmaceutical applications. A known substance which is just mere modification of it into a new form and claiming for patent again, or any new property, a new use of a known substance is also not acceptable unless there is an increased enhanced efficacy. If there is a technical evidence for enhanced efficacy, then it can be accepted. And mere admixture with aggregation of properties, the arrangement, rearrangement. Method of agriculture and horticulture is also not patentable in India. Medicinal, surgical treatment methods. I just go through it very briefly. I'm not explaining in detail because it will be covered. I hope it will be covered by Ashwini in the next session, because that session is full of patents. So I'm just briefly mentioning this, not giving many examples. And there are plants and animals are also not protected, but it can be protected with other rights. We have plant variety and farmers' rights, mathematical models, business methods, and literary, dramatic, and all these are covered under copyrights. So they cannot be protected under patents. Mere scheme of rule, method of performing mental act, presentation of information. This PPT are my performance, my presentation. This is, I am delivering this information in a particular way. This is my expression, but it cannot be protected under patents. Okay. Next, an invention which is traditional knowledge. Anything that is already in traditional knowledge, that can also be patented. Other than that, one more thing is anything related to atomic energy related inventions for the different purpose, that is also not patentable. And what are trademarks? Trademarks are any logo, design, or the label, the color, or the shape, the 3D shape of a product, anything that is related to or associated with any goods or services. So when you see the mark, how the consumer perceives it. When you see the mark, the consumer, the mind of the consumer should lead to the product or the service. Okay, then it is considered as trademark. It should be distinct in nature. It should not describe the product. It should not be descriptive, and it should not be deceptive also. That means distinctive in the sense it should not my product is electric fan. So just naming my fan as a fan, my trademark is a fan. That is descriptive. Or speedy fan or salty biscuit. These all are descriptive. So these cannot be trademarks. It should have some distinctive aspect to it, and it should not deceive the consumer. It should not deceive in the sense it should not infringe others' rights. Like you might have seen some many fake products, simple change of letters and playing with the vowels. They make products with the mark which is similar to the, which is almost similar to the existing big trademarks. So that is deceptive. So that's also not accepted. And in case of trademarks, it can be renewed every 10 years and it's unlimited in nature. There are various types of trademarks. Product marking. If the mark is someone please please mute your mic. Participants, please mute your mic. I think Dr. Gunasekaran. Thank you. And if the mark is used for service, for example, beauty service, medical service, legal service, educational service, if you register a mark for your institute logo or name, then it is service mark. And the certification mark is like BIS, ACMARC, any kind of, it links to the quality of the product. The standardizing authorities, they provide these certification marks. Collective marks is a group of people for a community. Lawyers have their symbol and doctors have their logo, right? So these are collective marks. For CA also we have a logo. And other than that, well-known mark is nothing but it has the, it is very, very well established. One thing you have to remember, like trademarks are registered under particular class. There are around 45 classes of goods and services. For example, food products, dietary products, and electrical goods. So all those things, there are around 45 classes are there, 36 plus 9. And so these well-known marks, they can restrict infringement in all classes of the trademarks. Example, if my product, I'm for in Amul, you know, Amul is, you all know Amul is for dairy products, but the same Amul mark cannot be used for electronics. Anyone else cannot use for electronics, but because it is recognized that well-known mark. If it is not recognized, then that would be a problem. Electronics and dietary products are not at all related to each other. Okay. But in case of recognition as well-known marks, they have established their brand. There are certain factors to it. So when they are recognized, then they can protect it. Their scope of protection is wide. And what all can be protected on trademarks? Any word, term, any brand name. And device mark is nothing but logo or the whole design of a packaging, label, all those things. Color, the purple color for Cadbury's, and 3D marks, the design of Toblerone chocolate, and McDonald's M mark, that's a 3D mark. And sound mark, like we have that is Nokia Tune and MGM, Roar of the Lion, and Britannia. This sound, all those things are related. When you hear that sound, you remember the product. Okay, so that's how they have associated the mark with the product. These are some examples. This covers many of. See, this is a device mark, and this is a product mark as well as service. And natural service mark. This is a certification mark, FSSAI, for food products, BIS, ISI. And see, this is a sound mark. And these are collective marks. So after that, what are copyrights? Copyrights, there is a difference between, there's a huge difference between copyright and patent. See, patent protects a technical aspect of a product. Copyright protects the expression of ideas, expression of thoughts. Okay, when you write a paper, write an article, research article or review article, so that is your way of expression. Okay, so copyright protects only the expression, not actually the method. See, if you have invented a process, and for the process, if you want to protect the process itself, commercializing the process itself, then you have to go for patents. But once you write the method in a particular format, whether it is in a flowchart, whether it is in a literary paragraphs, then it will be covered under copyrights, the expression of it. This this presentation, this PPT has full of contents which are facts. These are already there. These are not new. These are not I'm not making up these contents. Okay, these contents are there, but these are facts. But the way of expression, I am choosing the slide. I am choosing the color of it. I'm choosing how it should be expressed. These are the things are covered by copyright. So this PPT, I own the copyright for that. Okay. Also, the presentation, with the same PPT, any other person presents, it will be different. He or she will be presenting in his or her own style, own expression, way of expression. So that differs. So I own copyright for my presentation and my performance over that. Okay. It should be original. Originality is given. Original means you should be the author. That is the only criteria important for copyrights. So these are the categories: literary works, artistic, dramatic, musical, sound recording, cinematographic works. And this is how the default ownership. If there is no other contract or agreements, so this is how these are the first owners who are considered as author, creator of the work. And for copyright protection, it's automatic in nature. It doesn't need registration. It doesn't need, but you should have an evidence saying that you actually own the copyright. You actually created the work. And other than that, there is no need for registration. You can straight away go for enforcement if someone is infringing your work. Enforcing is nothing like you go for legal remedies. Okay, and it covers both. Copyright is not just the right to copy. Okay, so there are many rights associated with that. Economic rights like right to perform, the right to communicate to the public, right to reproduce the work, right to broadcast, right to adapt, right to translate. All these rights are coming under economic rights. So getting some commercial benefit from the rights. And moral rights are any right linked with authorship. So to have recognition that you are the author, that is the thing, and there should not be any disruption to the work. So all these are moral rights. Even though you transfer your economic rights, when you sell or when you assign your copyright to someone else, the economic rights are transferred, but not moral rights. Moral rights lie with author all the time. Okay, and the term of copyright is 60 years. It's calculated from the death of the author. I mean, the next year of the death of that. That means death and the first publication of the work. If I publish my work today, my 60 years period will be calculated from January 1st, 2023. Okay, so that's why you see in books, you see with the symbol copyright, only year is mentioned, not the date of publication. So only the year is mentioned. And moving to industrial designs. See, industrial designs and patents are misunderstood as the same, but they protect different aspects of the products. So industrial designs protect only the aesthetic aspects, not the actual technical functional aspect behind the product. Okay, for example, this bottle is designed in such a way, it has some functional aspect, like this top cover, it has some functional aspect. So for example, easy way of opening, and it holds the water firmly and it doesn't spill, and the angle of it for easy consumption of water, and all those functional aspects are protected by patents. But this covers industrial designs as well, because the external appearance of it is differing from other products. Okay, this is uniquely designed. So this external appearance can be protected under industrial designs. Okay, but it doesn't matter if the functional aspect is inventive or not. Design can be original and it can be protected. Okay, so the term of protection is 10 plus 5 years. that means it can be extended up to 5 years after 10 years of initial protection. And these are some examples. Designs cover everything, almost everything, industrial products, like from food products, biscuits, and especially in fashion industry, design of clothes and accessories, all those things. See this chair, here also there are functional aspects, why this chair is in this shape, in this, how it is made, the material of it, all those are functional aspects. But the external appearance of it is covered by industrial designs. Okay. So there is a separate set of rights. This is very unique. In India, we have plant varieties rights and rights for farmers also. Okay, plant varieties rights is nothing but breeding of plants to produce new plant varieties. This can be done by any mere farmer or agricultural scientist. So with that, the developed new plant varieties can also be protected under this. We have a separate authority, separate organization for this. And the conservation, as India is an agricultural land and it has a huge diversity, biodiversity, and conservation and improving of the plant genetic materials by the farmers, that is also recognized in this. Okay. And we have a separate design registration for semiconductor IC layouts. Okay, so layout of transistors and other circuit elements. So apart from industrial design, this is a particular, we have even a separate authority for this, but nowadays it's improving, and the applications are very less as of now, but it's improving day by day. It's a very recent one. And we have trade secrets, which are confidential information kept inside the business. Okay. Sometimes you don't want to disclose it as patents, because patents require complete disclosure of your invention. The purpose is like after 20 years, it should go to public domain for the use of everyone. But trade secrets are information that can be kept inside inside an organization, inside a company, okay, inside the business, and but it's critical, like protecting the confidential information is coming under contract law in India. There is no particular legislation for trade secrets, and it's like your deeds or agreements with the employees, and when you process it, and others are not physically separating the information from access of others. All those aspects are covered. And for example, the ingredients of Coca-Cola and the KFC ingredients, these are kept secrets. These are not published. Patent documents are published. Okay, so these are not in public domain. These are not protected under patents also. So they maintain the trade secret. This is to extend the protection. Trade secrets can be kept as long as possible. Okay. So another important, this is quite not directly relevant to entrepreneurship, but this is like a very important aspect in India. Like we have a huge variety of products or goods which are traditionally made and which are linked to the specific geographical location. Okay, the specific, the uniqueness of the product comes from it's directly linked to the location. For example, Madurai Malli, Tirupati Laddu. So all those products are protected under geographical indication. Okay. So these rights are given to a community of people. It's not given to individual. Other rights, any other right can be registered or granted to a particular person. But this geographical indication is provided to a community of people, not to a particular individual. And the GI cannot be transferred. It cannot be mortgaged. It can be licensed, because it is given to the community, to the association of people, not to a single person. And if the term is unlimited, it's more like a trademark. Okay, so there we have a logo for every in a registered GI product. That logo can be used for promotional purpose and for marketing. So that logo cannot be used by any other producer in any other places. Okay, because while registering geographical indication, we provide a map of it. So only those who are registered in the association in the particular region of it will benefit from that, not others. So these are some examples. These examples are mostly from those from Tamil Nadu. And a quick brief of why do we need these kind of IPR? Why government is spending money or forcing academic institutions to have these IPR awareness? Why? Because earlier we didn't have that. See for how government is doing, like you through various ranking authorities, or like NIRF, Fatal ranking, and accreditation bodies like NAAC, NAC, and UGC. So they are in some way, directly or indirectly, they are asking to make it as an elective course. They are encouraging creation of IPR cells. They have guidelines for IPR cells, and they have they give credits for this kind of IPR programs, and they fund for IPR awareness. So see now in academic institutions, so earlier teaching was the only purpose. Okay, later it gradually we included research over it. So research was given more important, and teaching and research went hand by hand. After that, research, innovation, and now we just directly go for publication. So these, I don't know, we were evolved like that. We go for publication. The publication culture was very much deep rooted in academic society, like because when you publish it, you lack the technology, the invention lacks novelty from that publication. You cannot file for patent. You cannot protect your IP. Okay, so the research, I'm hearing my echo of it. Okay, thank you. And so nowadays the institutions are pushed towards IP generation, transferring technology, and looking for investors and commercialize it, and so that the money or royalty from commercialization is turned back to research again. Okay, so these are the roles of IPR cells. So there should be an IPR cell established in an university or a college, and it should have a institutional IPR policy, and the IPR cell should maintain industry partnership and finding investors, projecting the institution's IP, and displaying it to the investors to attract investors. Also, it provides consultancy to the scholars and faculties, which IP can be applied for which of their works. All those consultancy works and technology in the future, at least in these two should be covered now. In the future, technology transfer and how the management of IP is done, all those have to be provided by the IPR cells. And the government is providing so many, is doing so many promotional work for IPR, and in terms of sensitization, training, facilitation, and technology transfer. So these are the collection of organizations that we provide services, but this is my collection. There are other organizations as well. This is not exclusive list. Okay. And if you have any other clarification, you can contact us. If you have any query now, I can address that. Thank you for your patience.
Thank you, ma'am. Requesting all the participants, if you have any queries, please type in the chat box or you can unmute yourself and ask madam. I suppose there are no doubts. And with this note, on behalf of the institution's Innovation Council, IAC of SciTech Puttur, I, Kausalendra, the convener of IAC, thank Madam S. Gomathi Padmatilaga, who is a Scientist B, Patent Information Center, Tamil Nadu State Council for Science and Technology, Chennai, for the exemplary and informative session on role of IPR in entrepreneurship. She's a scientist, a facilitator for startups in patents and designs. Also, she's a patent agent. And each one of us at IAC of SciTech are extremely grateful to you, madam, for sparing your valuable time for us and for enlightening us regarding intellectual property. The examples that you have given throughout your presentation are really helpful. Also, the information that you have given about the mistakes that startups make, the IP strategies, the criteria for patents, and some of the interesting things like the patents for different types of paper clips were really interesting. And also you covered about the types and categories of trademarks, criteria for copyrights, and the classes of goods and services. Your presentation is really outstanding, and we are very fortunate to have you as a resource person. And we look forward for a few more sessions from you, madam. We're really delighted for your time. I guess you are in a different time zone. Thanks for all the effort that you have made for making your presence with us. Thank you so much, ma'am.
Thank you, sir. My pleasure is mine. Thank you so much.
Requesting all the participants if we could have a group photograph with Madam Gomathi. Requesting all of you to please turn on your cameras. Just a minute, ma'am. We'll be taking one group photograph. Thank you so much. Thank each and every one of you. Thank you, madam. Requesting all the participants to please join for the post-lunch session as per the schedule. Thank you. Dear participants, requesting all of you to please join the afternoon session at 2 p.m. Requesting to join before 10 minutes. We're now ending the session. Thank you all for your time and see you this afternoon. Good day.